Welcome back, eDiscovery viewers. Today we're talking more about legal terms. As you know from a previous video, this is for tech folks out there who don't know what certain legal terms mean. If you have a law background, this video is not for you. Today, we're back again with Yitzi. Yitzi, thank you for joining us again at the studio. I got 3 more terms for you to help us understand. And we're gonna start with deposition. The way I hear the word deposition is when the client calls us up and say, I need these documents because we have a deposition at so-and-so, get it to us right away. What is deposition?
You're going to basically question one of the key players, and they have to testify basically under oath. This way you have a transcript of what goes on, but basically at the deposition you introduce evidence that you want to introduce. That's why you go to find the critical documents that you want. Okay. Because you're trying to prove your case. For an example, in a patent case I had, I went through some of the people who were the creators of the invention. They wanted to point out to it, and they would go to their lab notebooks and said, here, you say you based it off this type of article, and they wanted to prove that basically if you just had that article, that would be basically enough to recreate. So you want them to admit to that on the deposition. They have to be truthful, but the lawyers try to tell them how to be evasive, and the idea is not to give too much information. Don't give freely at these things, usually, but that's what you're doing. You're building your cases, so therefore you need the right documents because you're going to be introducing the deposition for him to see and question him about it.
Well, okay, I think that answers pretty well. Let's just move on to the next one, which is arbitration. Now, that one I don't hear too often. Sometimes it shows up in an email once in a while.
So arbitration is different than a trial because there are less formalities. Your rules of discovery are looser, they're faster, there's less chance of an appeal. Basically, arbitration is supposed to be like a third-party mediator.
Right.
You don't have nearly as much discovery per se, depending on the case, and you don't necessarily have formal rules. Like in legal proceedings and trial, there are formal rules that you have to hand things over. They're a little less formal. Plus, depending on what it is, it may be binding or not binding. They can't necessarily be overturned as easily. With trial courts, depending on it, it can be overturned, which gets to your next term.
Right. So arbitration is not a trial. It's sort of opposite of a trial.
Not opposite, but it's similar. But the idea is it's a different route. It's a faster route for general and things. It's usually less rules of discovery. It's more of an informal type of setting, and it's basically cheaper.
Got it.
For the most part, it's a cheaper process because what happens is with trial, it can take forever with the court's docket, with all the rules of discovery. With arbitration, things get fast-tracked a lot more, and you have a third-party mediator who you pick from a pool, so you're not necessarily dealing with the same trial judges.
And the mediator is just going to make that decision, and that's going to be...
Well, you have to agree to a binding arbitration, and depending on your agreement, it may not be appealable, it may be appealable.
Right, and then speaking of appeal, that is our third word for today.
So an appeal is essentially when you lost originally and you're appealing the decision to overturn it based on the facts, generally not factual, or there was an issue of law that was incorrect on the lower court rulings. So depending on what it is, it may be that there's different reasons why, but an appeal is basically you're taking it to higher court, saying something was wrong at the lower court. There has to be a good basis, and you can't necessarily appeal on a basis that wasn't introduced at the lower court. So if there's a great argument that the lawyers over there messed up and didn't introduce, you can't bring it up on appeal. Usually it has to be in the record at that point.
Right.
So appeals are basically lower court rulings made a mistake. I'm appealing to overturn.
And it's not just because you're not happy with the results. It's because there was a mistake in the process somewhere.
Right, but usually you're going to do it because you're unhappy, and then you have to find some reason why there is a mistake in the rules. I mean, Supreme Court only hears appeals. It doesn't go straight to the Supreme Court.
Got it. All right. Thank you very much, Yitzi. Guys, if you got more terms that you want us to go over, put them in the comment section below. Don't forget to check out eDiscovery on social media networks listed on your screen. And for previous videos, check us out on YouTube. Thank you.